Welcome back. This is part 2 of thoughts regarding Sunday law, and we'll begin with prayer. Our loving God in heaven, we thank you for these times that we are living in. We thank you for the knowledge that you've given us so far. And as we wake up to important things happening externally and also things happening internally, we pray for wisdom from above, that we might navigate these times correctly. We ask for your presence now to guide our minds and hearts as we discuss these topics. We ask this in Jesus' name. Amen. So, a brief review of what we did yesterday. We started by looking at Acts 27 and how those parables, those lines of the two ships, take us down to Sunday law. And they represent the United States and Adventism, the two institutions. And we specifically looked at, reviewed the 276 souls on board the ship that are given us in Acts 27:37, and how that number was used a number of ways, two different ways, to identify the Levites, but also to take us to 273 BC. And 273 BC was when Egypt sent ambassadors to Rome, because Rome had arrived on the world stage after defeating Pyrrhus in the Pyrrhic Wars in 275. And then in 272 BC, Rome sends ambassadors to Egypt. We note that waymark is Sunday law and shipwreck. So 272 BC, Rome sends a delegation to Egypt. We note that that's the fall of Tarentum, the Battle of Argos, Pyrrhus dies, and that it's Quintus Fabius Maximus Gurges that heads that delegation to Egypt in that same year. It's his name, Maximus Gurges, that identifies Sunday law, the maximum flood. From there, we went to the books of Daniel and Revelation to identify some of the characteristics of a flood. And we noted 538, and the flood of 538 was all the laws of Justinian, in particular the Sunday law at the Council of Orleans in 538, and how the king and the kingdom changed at that time, from the pagan Roman Empire to the Holy Roman Empire, from a head of state to a theologian, or what some people call Caesaro-papalism. Then we went to the end of the 1260 and we noted the flood at the end of the 1260, which was the counter-revolution. And that flood of doctrines and information and teachings that threatened to sweep away God's church. The only solution for the church, for its safety, was to change continents. And the earth helped the woman, the United States. And we note that as its constitution and the religious liberty and freedom that it could gain in the New World. So we then went back to Quintus Fabius Maximus Gurges and noted that the use of Roman nomenclature and how Fabius is an important part of his name. It's his nomen, it's his surname. It identifies where he's come from and the authority that he has belonging to that clan. He was of the Fabii gens, which was a very important tribe that ruled Rome for quite a time. The meaning of Fabius, it's Fabii, they were bean farmers. Faber, the fava or broad beans, are connected with voting and elections. So because of that name, we've gone to look at the voting rights in the United States in the glorious land. So we're going to jump in where we left off yesterday, and I'll just go to our PowerPoint. we started back at the middle of the Dark Ages and the Magna Carta, how that was the dawn of human rights that led to the Enlightenment period, and it was Enlightenment ideas and philosophies that influenced both the French and the American Revolution. Okay, so then we came down through time. We looked at the important documents. We looked at the Declaration of Independence and the Constitution, how there is no right to vote in the Constitution, even though it mentions it voting 40 times. We learned that the Founding Fathers actually really struggled over that issue, how to establish the country where you would have majority rule that would protect minority rights. And so because of certain concessions that they had to make with the states in order to ratify the Constitution, the elections were left with the states. And if you're to read some of the founding fathers, and I mean, that's what they're referred to as, their thoughts at that time, some of them were very concerned about where that would lead in the future. And so it was necessary that amendments be made to the Constitution. The Constitution was largely to restrict democracy, because pure democracy can be dangerous. It leads to mob rule, as it was in ancient Greece. So there had to be restrictions on democracy, and they are written into the Constitution. So amendments were necessary. We came down and looked at the Civil War period in 1863, and then we've gone to the end of that, the end of the Civil War, and the amendments that were made post-Civil War. This is the 15th Amendment, that the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. The Congress shall have power to enforce this article by appropriate legislation. So this is a very important amendment. It gives the right to vote to all people, to Black males, women, and other minorities, and those between 18 and 21. They're going to have to still fight for their right to vote, but there was to be true multiracial democracy in the South during Reconstruction. So Reconstruction began after the Civil War ended, with the idea of bringing the South back into the Union. So under the 15th Amendment, see, notes the Congress shall have power to enforce this article. Federal troops were sent down into the South to help establish, get people on the electoral rolls and make sure that this amendment would be enacted. However, this was a really glorious time. For 10 years, there was an amazing change in the South, and we see Black governors and Black senators elected during that time. But the end of Reconstruction was marked by the removal of federal troops from the southern states after something known as the Hayes-Tilden Compromise of 1877. This is going to change the fortunes of Black voters in the southern states. The election was very close. So what happened was the Southern Democrat, Samuel Tilden, he said, I won't contest the results. I'll concede to the Republican president-elect Rutherford B. Hayes, as long as you remove federal troops from the South. And so the North said, okay, we'll take out the federal troops, and if you'll let Rutherford B. Hayes be the president. So that was the compromise. But the removal of federal troops would lead to a climate of violence and intimidation against Southern blacks that would repress voter turnout, and then there would be blatant fraud at times that would even overturn some of their lawful election results. So immediately after that, basically from 1888 to 1908, every Southern state started passing Jim Crow laws. And these laws were specifically denying Black people the right to vote. States like Mississippi and Alabama started passing things like poll taxes. You had to pay money to vote. Literacy tests when there was so much illiteracy. Grandfather clauses. So with a grandfather clause, so you might be poor and white, so you can't pay the poll tax. But if you could prove that your grandfather voted, then you could vote. Of course, Black people, their grandfathers were probably slaves and they didn't vote. So grandfather clauses were highly discriminatory. I had to have property requirements. In some counties, in order to register to vote, you had to name all the 67 county judges just to get on the roll. There was widespread economic social retribution for being on the voter registration, and violence and fraud. Because some states refused to comply with the federal law, Congress had to enforce the Enforcement Act of 1870. So they brought in an Enforcement Act with criminal penalties if these southern states interfered with voting rights. However, in 1875, the Supreme Court came out and said, no, you actually don't have a right to do that. The Enforcement Acts are unconstitutional. And this ripped the teeth out of the Congress's ability to enforce this 15th Amendment. So the Congress did step in to try and enforce it. The Supreme Court came in and said, no, unconstitutional, which basically meant that African Americans were totally written out of the political system. And it's going to stay that way right up until the Civil Rights Movement. So beginning in the 1890s, some states amended their constitution and enacted laws to include poll taxes, literacy tests, grandfather clauses, all white primaries. You had to have a voucher of good character, property requirements, all this sort of thing. By 1910, nearly all Black citizens were removed from the voting rolls of the former Confederate states. Restoring these rights would take a 55-year struggle, because the Supreme Court would keep intervening. So we'll come down to 1920 and we've got the 19th Amendment. So women have been fighting for the right to vote. That's the suffrage movement. It's been going on for the better part of a century. And although they contributed to the founding of the country and helped pioneer the West, it took World War I to make it a reality. Because during World War I, the men were away fighting. The women became vital at supporting the country at home. They worked jobs in industries traditionally held by men, and they gained much respect in the eyes of the country. So after the end of the war, women finally gained the right to vote. First, only white women, and then there would be an extension to the amendment for all women. So 1920, the 19th Amendment was added to the Constitution. Now, a suffragist, shift me over here, oops. A suffragist could be a man or a woman who believed in extending the right to vote, also known as suffrage. So a suffragist is somebody who wants to extend the right to vote. So where do we get this word suffrage from? It actually comes from a Latin word for prayers. Prayers said after a departed soul. Now remember, our beans were also thought to represent the souls of dead people. And this is where the word suffrage comes from. It's the prayers that are said after a soul departs. And the word was broadened to refer to voting a cast in favour of someone. A vote cast in favour of someone. And eventually we understand it today to mean the privilege or right to vote in general. but its etymology, the roots of it is prayer, intercessory prayers, particularly for dead people. Another word that we'll see repeatedly is enfranchise. So people are enfranchised when they're given the freedom to vote, and they're disenfranchised when they're deprived of the right to vote. This is the Catholic Dictionary. Suffrages, the prayers prescribed or promised for specific intentions. More particularly, suffrages are the masses, prayers, or acts of piety offered for the repose of the souls of the faithfully departed. So as we noted earlier, November is dedicated to the holy souls in purgatory. It's a month of prayer. November 1, All Saints' Day. That's, you pray for the church triumphant, those in heaven. November 2, All Souls' Day. You pray for those in purgatory, the church suffering. And All Souls' Day is when you plant your faba beans. Now, I won't read this for time, but this was that pamphlet on suffragists, and these are 12 reasons why women should vote. So if you're watching a recording, it might pay to just pause and read through those reasons. That they're very good, although we would probably reword some of them today, slight patriarchal tone in some of them, but otherwise 12 good reasons. We've also learned in the past that the word suffragette was, the word suffragette was derogatory. When you add "et" to the end of a word, it makes it a smaller than usual. So it was meant as it's calling women inferior. It was used by those who opposed the suffragette movement. We're going to come down now until 1948, so post World War II and the Universal Declaration of Human Rights, or UDHR. So in 1948, following the traumatic events of World War II, representatives from the 50 member states of the United Nations banded together to create a list of the rights everyone around the world should enjoy. Under the guidance of Eleanor Roosevelt, then First Lady of the United States and a politician, diplomat, and activist in her own right, the Universal Declaration of Human Rights was born. It's a milestone document in the history of human rights. It was proclaimed by the United Nations General Assembly in Paris on the 10th of December 1948 as a common standard of achievements for all peoples and all nations. It sets out for the first time fundamental human rights to be universally protected, and it has been translated into over 500 languages. It's widely recognised as having inspired and paved the way for the adoption of more than 70 human rights treaties applied today on a permanent basis at global and regional levels. This declaration is not a treaty, so it doesn't directly create legal obligations for countries. However, it is an expression of the fundamental values which are shared by all members of the international community, and it's had a profound influence on the development of the international human rights law. In 3 concise paragraphs, Article 21 outlines some of the fundamental principles of democracy. Everyone has the right to take part in the government of his country directly or through freely chosen representatives. Everyone has the right of equal access to public service in his country. The will of the people shall be the basis of the authority of government. This will shall be expressed in periodic and genuine elections, which shall be by universal and equal suffrage, and shall be held by secret vote or by equivalent free voting procedures. So note that this article does not actually include the word democracy. In fact, the word democracy doesn't appear anywhere in the UDHR, except for one reference that is about a democratic society. So why? Why didn't they write democracy? And that's because fresh in the minds of these UDHR drafters was the election of Adolf Hitler. and he was elected through democratic processes. And then he subsequently rejected the very same processes that are a foundation of the democratic state. Instead, he advanced the Führerprinzip, or leader principle, based on the philosophy that the best, strongest, and brightest should rule the weaker and less pure. Such a leader would command total obedience from those under him, and he was above and therefore could totally disregard the rule of law. So it takes you back to what was trying to be achieved with the Magna Carta. We see that totally turned around with the election of Adolf Hitler. So in this respect, like so many others, the UDHR can be seen as a key part of the world's attempt to inoculate itself against any future would-be dictators. So that's 1948. Now, the civil rights era that started in the mid-1950s, the American Civil Rights Movement. A major catalyst for the push for civil rights was in December 1955, when NAACP activist Rosa Parks refused to give up her seat on a public bus to a white man. Black Americans, along with many other Americans, mobilized and began an unprecedented fight for equality and social justice that spanned 2 decades. Their aim was to abolish legalized racial segregation, discrimination, and disenfranchisement in the country. Disenfranchisement, remember, is to be deprived the right to vote. So in 1957, Martin Luther King Jr., he gives one of his major speeches. And I won't read this for time, so you might want to again pause and read it. But what King is going to do is position voting rights as the center of the struggle for civil rights. He emphasizes the gravity and impact of voting, saying, so long as I do not firmly and irrevocably possess the right to vote, I do not possess myself. So it's a very powerful speech. He says, give us the ballot. Give us the right to vote, the freedom to vote, and we will no longer have to worry the federal government about our basic rights. Why? Because they will elect the people that will protect their rights. And this is the second part of that portion. So what was America like at this time? The statistics are staggering. 6.7% of African Americans are registered to vote in Mississippi, only 6.7 of them in 1964. In a county like Selma, Alabama, only 2% are registered to vote, and that's existed for decades. In 1964, we're going to see the Civil Rights Act of 1964. The Civil Rights Act is a landmark civil rights and labor law in the United States that outlaws discrimination based on race, color, religion, sex, national origin, and later sexual orientation and gender identity. It prohibits unequal application of voter registration requirements, racial segregation in schools and public accommodations, and employment discrimination. The Act remains one of the most significant legislative achievements in American history. So at this time, poll taxes were abolished and declared unconstitutional under the Civil Rights Act. But voting rights is going to continue to be played out in the courts. There's still massive discrimination. So this is the 24th Amendment. The rights of citizens of the United States to vote in any primary or other election for president or vice president, for electors, for president or vice president, or for senator or representatives in Congress shall not be denied or abridged by the United States or any state by reason of failure to pay any poll tax or other tax. So again, this amendment to the Constitution, it's going to abolish poll taxes. But here's the problem. A Congress shall have power to enforce this article by appropriate legislation. So remember that the Supreme Court had previously decided that this was unconstitutional. So again, after the passing of the 24th Amendment, this is going to be played out again in the courts. So a lot of cases will come before the Supreme Court. And this is a quote from Justice Hugo Black regarding voting rights, again, 1964. "No right is more precious in a free country than that of having a voice in the election of those who make the laws under which as good citizens we must live. Other rights, even the most basic, are illusory if the right to vote is undermined." So the most precious, the most important right that you have is the right to vote, because all the other rights that you have get undermined. So whether that's the right to reproductive rights we're going to see get undermined if the right to vote is undermined. This is Chief Justice Earl Warren, again, 1964. The right to vote freely for the candidate of one's choice is of the essence of a democratic society, and any restrictions on that right strike at the heart of a representative government. Undoubtedly, the right of suffrage is a fundamental matter in a free and democratic society, especially since the right to exercise the franchise in a free and unimpaired manner is preservative of other basic civil and political rights. So he's saying the same thing as Justice Hugo Black. Any alleged infringement of the right of citizens to vote must be carefully and meticulously scrutinised. So if there are to be changes, if there are laws about elections, about voting, they need to be scrutinised meticulously and carefully. So they have both said, both of these justices have noted that voting rights are fundamental to preserve other basic civil and political rights. So 1965, here is a quote from Martin Luther King. "There must be change. There will be change. For to deny a person the right to exercise his political freedom at the polls is no less a dastardly act as to deny a Christian the right to petition God in prayer." So what is he doing? He's giving a parable, an analogy. Deny a person the right to vote in a political election is the same as denying a Christian the right to petition God in prayer. So the Civil Rights Act was passed in 1964, but the civil rights movement is still pushing for voting rights. Immediately after the passing of the Civil Rights Act, President Johnson starts talking to his advisors about going after voting rights, but his advisors are saying, not now. There's other things that we want to do, and we'll lose the Southern Democrats if we force voting rights now. They'll be mad at you. They won't support your other plans. So Johnson's going to back away from voting rights. It's still on his agenda, but it's not a priority. However, on the ground, things are changing. Interest groups are getting involved, and they're going down to the South to try and enfranchise African Americans. And these groups start clashing with state forces. They are not going to be allowed to vote. And Martin Luther King, he gets arrested, and he writes a letter from Selma, Alabama jail, which gets published in the New York Times. And people right around the country start seeing people getting arrested and beaten. And they read about voting rights in the New York Times. And then there's more pressure put on the Johnson administration. So they have to start moving on it. And what happens is a man called Jimmy Lee Jackson, he gets killed in Selma, Alabama. There's a skirmish and he's trying to protect his mother, and a cop shoots him. And this pushes this movement and these activist groups over the edge. And they start doing these marches. And one of these marches is they're going to march from Selma to Montgomery, an 87-kilometre march. And what they want to do is make sure that they get people registered to vote. And there's this famous conflict that happens just as they're starting their march in Selma. They're crossing the Edmund Pettus Bridge. Now, Edmund Pettus was a grand dragon of the KKK. So they're crossing this bridge. There's 600 protesters, and they're about to get tear gassed, beaten, and trampled on by horses. It's referred to as Bloody Sunday. And this is going to be it for Johnson. He's going to have to go on television and address the nation. So here we've got a picture, March 7, 1965. And what you're seeing here is John Lewis. John Lewis in the foreground, he is about to be beaten unconscious. We mark John Lewis as part of the counter-revelation. He died on July 17, 2020. He's about to be hit by a billy club. He is chairman of the Student Nonviolent Coordinating Committee, rather ironic. And these state forces are wanting to break up this civil rights voting march in Selma. He gets a fractured skull here. He carries this struggle about voting rights to his death. Now, this is really an amazing time in American history because the state forces here, they're so bold. They're surrounded by television news cameras. They're filming this, and they don't care because they feel so emboldened. But what happens is that America's ABC News broke into their prime time premiere of Judgment at Nuremberg. It's a film about Nazi Germany, to show images of what is happening here in Selma, Alabama, of police beating civil rights demonstrators. And many Americans were so confused, they thought the images from Alabama were actually from Nazi Germany. And that's how chilling it was. This march shook the conscience of the nation like no other. And 8 days later, Lyndon Johnson is forced to introduce the Voting Rights Act. And then it passes 6 months later in August of 1965. It really was a revolutionary piece of legislation. John Lewis was known as the conscience of the Congress because he spoke out and stood up for the rights of all, regardless of race, gender, or philosophy. He believed in non-violent direct action as a way of speaking truth to power. He was arrested 40 times and beaten often, and he fought for voting rights right up till the end. So you can read that at your leisure. It is one of the most far-reaching pieces of civil rights legislation in US history. It fundamentally changes the relationship in federalism in terms of how the federal government is going to have oversight into elections to protect minorities. It was a very simple piece of legislation to enforce the promise of the 15th Amendment, which has been ignored for nearly 100 years. This bill has multiple parts, but it's got three big pieces, big sections. First, it strikes down all the suppressive devices that had prevented the Black Southerners from registering. So literally overnight, they were gone. And then it sends federal officials to the South to register Black voters. Hundreds were registered in weeks, in days, thousands within weeks. Section 2 of this legislation says that if any state or locality wants to change anything in regard to how an election will be held, they have to prove that it won't have a discriminatory effect on voting. So it doesn't matter what the state or the locality says its original intent is, it's all about the result that that change will have. You might say, oh, we're not intending to discriminate, but if it can be shown that the result of that change would be discrimination, then the change could not go through. So this is called pre-clearance. You had to have pre-clearance to make any changes. Section 5 of the Voting Rights says that there's some states that need a little bit of extra oversight because of how badly they've discriminated in the past. So if you've already got discriminatory laws on the books, then you go to Section 5. And the other section that's of importance is Section 4, because it's about the formula which will work out if the states have been discriminatory. So they might look at, say, the voter registrations. And they'll say, well, you've got so many Black Americans in your county, but only so many are registered. And they worked out this formula. And that formula would be used to work out which states and which localities needed pre-clearance for their changes. So a state might say, we want to introduce a new voter ID bill. And it would have to pass by this, get through this act to say, well, this won't be discriminate against anybody. But under this act, federal observers are sent into these districts and they're going to keep an eye on all of this. So all of these laws or the states wanted to pass voting to restrict voting rights had to have pre-clearance. Here is a map of the covered jurisdictions. The main offenders, as far as voting rights, were back in 1965. So you can see that they are largely southern states: Alabama, Georgia, Louisiana, Mississippi, South Carolina, and Virginia. They were notorious for violating the rights of Blacks for much of their history. So what's going to happen is these states in particular, over time, they're going to try and get out of the mandate of the law of this VRA. Here is a slide of some board work that shows the political spectrum and how it changed over time. So if we go back to the Millerite time period, we note that in the North were the Republicans, and they were on the left of the political spectrum, and on the right were the Southern Democrats. But when we come down to our time, the right are the Republicans and the left are the Democrats. So how did that change go about? Two things, really. The changes, the policies implemented by Franklin D. Roosevelt because of the Great Depression, the New Deal, they were economic policies that a certain part of the country didn't like, but also the civil rights acts that were introduced in the 1960s, not just the CRA, but the VRA. So laws affecting desegregation, forced integration, and voting rights. These combined helped shift the Southern Democrats to the left and the Northern Republicans to the right. However, this is an oversimplification, because what the VRA ultimately did was allowed for moderate Democrats to also be elected. So if it wasn't for the VRA, there would have been no Jimmy Carter, no Bill Clinton. So it's an oversimplification to say that the South turned red overnight. So LBJ, Lyndon Johnson, he was a white Southerner, but he cared about civil rights. But he wanted them to happen on his own terms. But what these marches did was they forced his hand. So the VRA is introduced, and the backlash or the counter mobilization was immediate, and it was vicious. It only took a week for the first federal lawsuit to be filed, the first constitutional challenge. The major thing was that it deprives states, this is what the states, these red states are saying, that it deprived them of their rights to oversee voting and to set qualifications, which is clearly written into the Constitution. And the lawsuits don't stop. So with the VRA, some of its provisions have what are called sunset clauses. They have to be revisited every 5 years because the demographics of a state are going to change. So in particular, Section 4, the part that sets out the formula to work out if a state has discriminatory laws, that has to be revisited and reaffirmed. At first, it was every 5 years, and then it was every 7, and then it didn't get touched for 25 years. But there is strong bipartisan support in Congress for renewing it. And it gets renewed, the VRA gets renewed 4 times, all by Republican presidents, because of this strong bipartisan support in Congress. So you've got Nixon, Reagan, George Bush. They don't champion the VRA. And it doesn't stop them weakening parts of the act, but they have to revisit it and it gets voted in, despite these Republican leaders. Again, because of strong bipartisan support. So in 1970, it is reauthorized. 1975, it's reauthorized. However, each time it does get slightly watered down. Section 4, Section 5 remain strong, but there is some watering down of the law. 1982, it gets revisited and they say it's safe for another 25 years. So Congress isn't going to renew the special provisions of the VRA again until 2006. So we're going to have a look at what happens in 2006 in a minute. So by the time the VRA has been renewed and revamped for the 4th time, President George Bush would be signing in a 2006 version. But let's back up and note that there has been various attempts to dismantle the VRA ever since 1965. But in 1971, we see the 26th Amendment, which is going to give the rights of 18 to 21-year-olds, or anybody who's above 18, the right to vote, because what's happening, it's the Vietnam War, and they're sending 18-year-olds off to fight this war, and they don't have the right to vote. So it's recognised that if you're going to fight for your country, then you should have the right to elect the people that are either going to send you away to fight or who won't send you away to fight. So very important connection there. So 1971. We want to mark 1979 because 1979 is where we prophetically mark the moral majority. We prophetically mark a change from racism to gender. Prior to the late 1970s, early 1980s, the emphasis has been on the social issues that focus on Blacks: racial inequality, civil unrest, civil rights, busing, affirmative action. But that is going to change, and we've discussed that in the movement many times in the late 1970s, early 1980s, where the issues of gender, the family, education, and the relationship between church and state are going to rise to prominence. But it's particularly women's rights, especially abortion, and the Equal Rights Amendment that are the most important. So here, Paul Weyrich is going to say in August of 1980, I don't want everybody to vote. Elections are not won by a majority of people. They never have been from the beginning of our country, and they are not now. As a matter of fact, our leverage in the elections quite candidly goes up as the voting populace goes down. So he's right there. Right back in the beginning of the country, it was a minority of people that that were able to win the election because of how the voting rights was. But he's been quite candid here in saying that they needed to have a minority of people, that their power in the electoral process actually goes up as the voting populace goes down. Now, we note that the alpha test is not the omega test. In the alpha, gender was an issue, but it's not the test. And in the omega, race is an issue, but it's not the test. So our test is gender. So it's not just about who gets to vote, but who gets to legislate. Not who gets to office, but what they will do in office. So blacks and immigrants were at that time more likely to vote Democrat. So it's not about them being black anymore. The issue now changes to gender, even though there's still racism. So, as mentioned earlier, in 2006, the VRA is reauthorised for the 4th time. It passes 98-0 in the Senate and 390-33 in the House. But then we come down to Shelby versus Holder, 2013. So this was a huge decision. On June 25, 2013, the Supreme Court ruled that the coverage formula in Section 4 of the Voting Rights Act, which determines which jurisdictions are covered by Section 5, is unconstitutional because it's based on an old formula. As a practical matter, this means that Section 5 is inoperable until Congress enacts a new coverage formula, which the decision invited Congress to do. So the Supreme Court says, no, unconstitutional, Section 4, because what had happened in 2006 is they reauthorized it, but they didn't revisit Section 4. Section 4 was the formula to calculate if a state was restricting people's ability to vote, if there was voter discrimination. The demographics of a state will change. So the formula that worked in the 1960s might not be accurate in the 1990s. For example, a county might have been 90% black and only 6% registered to vote. So the formula would say, well, there's something wrong there. But then that demographic might change and that county might not be 90% black anymore. So the formula's got to change. The Congress would have to write a new formula and keep it updated, but they didn't do that in 2006. The Act was renewed, but they didn't change anything in regards to the formula. So what happens in 2013 is the states are saying, Shelby County says, we don't want permission anymore. We think it's constitutional. That it's unconstitutional. And the Supreme Court says, yep, you're right. Because in the original US Constitution, states are given the ability to come up with their own rules, how they want to run elections. The 15th Amendment steps on that. Shelby County says it's unconstitutional. It's not fair. The court says, you're right. Section 4 is outdated. Congress didn't update it. So while Section 5 is still good, it's just useless. It's, because there are pre-clearance isn't needed anymore. So the Voting Rights Act of 1965 is pretty much today a dead law. A central portion of it was deemed unconstitutional and struck down by the US Supreme Court in 2013. The Supreme Court said history has changed, but the Voting Rights Act has not, and it continues to treat the country like it's stuck in the 1960s. And look how we've progressed. We are so much better now. We don't discriminate like we did in the 1960s. There is no discrimination. But what the Supreme Court didn't take into account was that it was the VRA that allowed that to happen. It was the VRA that kept the states honest. Because between 1965 and 2013, there were 3,000 discriminatory laws which were prevented from going into effect. The VRA stopped 3,000 laws. It's those attempts didn't make it to the courts because they were stopped because of preclearance. So today, if you had noticed the recent Supreme Court judgment handed down regarding South Carolina, is these are now, but you've got to play these out in the courts. So a state might introduce a discriminatory law and somebody's got to take them to court for it. And then it's got to go through the process of the state courts and eventually end up in the Supreme Court. These things take time. And as in the recent handing down the Supreme Court, they get cast as, they are deemed constitutional. They're not looked at as being discriminatory. Today, voter suppression has got a lot cleverer. So there are no poll taxes, but there are things like there are just official ways and also unofficial ways to disenfranchise people. In 2016 and 2018, they were the first, or 2016 was the first presidential election in 50 years without the full protection of the VRA, and it had a profound effect. They were the first elections after Shelby versus Holder where people were literally disenfranchised. They were not allowed to register. Or if they were allowed to register, when they turned up, they were turned away because there was an alleged problem with their ID. There was pre-voting suppression. In fact, pre-voting suppression is actually more powerful than, trying to turn an election afterwards is nothing compared to suppressing the votes beforehand. Donald Trump was very open about what he was doing. He said that if you make it easier to vote, a Republican would never be elected again. So that's why he said he didn't want to fund the post office, because he didn't want to expand mail-in voting. He said that he would send lawyers right in there right after the elections. So so here's an example, 2021, the Election Integrity Act, ironically named, HB 531 of Georgia. So in 2020, there was a huge voter turnout in Georgia, and George Kemp, he narrowly beat Stacey Abrams. So the Republican-led House passed a sweeping bill, this is it, HB 531, the Election Integrity Act, to make it harder to vote in a move aimed at preventing Democrats from winning future elections. So once they get into power, what are they going to do? Make it harder to vote. Republican lawmakers introduced the legislation after record voter turnout because the bill limits access to absentee ballots, limits weekend early voting hours, and curbs ballot drop boxes, among other things. So you can see this picture here. It's very telling, actually. It's Governor George Kemp with a gaggle of white men around him beneath a painting of an antebellum home, a former slave plantation, Callaway House it's called, as they're signing in this Election Integrity Act. So one of the reasons that there was such a high voter turnout in 2020 is because there were much more options to vote than ever before. People could vote by mail in more states than ever before. They could vote early in person, and they could also register on election day. And the Republicans are trying to roll back those voting methods. So they target mail-in voting, restrict mail drop-off boxes, all those sorts of things. They stopped, the black churches would have Souls to the Polls Day, where on Sundays you'd go to church and then you'd go off and register to vote. All these voter mobilisation drives. So these are now targeted, and there are laws against them. Across the United States, Republican lawmakers have introduced more than 250 bills, more than that now, in 43 states aimed at restricting voter access. The Republican Party has no interest in appealing to a majority of Americans. Instead, they are doubling down on anti-democratic tactics so they can get a minority of votes but wield a majority of power. It's the biggest rollback on voting rights in decades. So here's an example. They shorten the window to apply for a mail ballot. This is just to do with mail voting. Shorten the deadline to deliver a mail ballot. Make it harder to remain on mail voting lists. Cut down the amount of time that people have to request mail ballots. Eliminate the ability of officials to send out mail ballot applications. Cut the number of drop boxes, things like that. And then there's stricter ID requirements for mail voting. And that's just the laws regarding mail voting. There's also laws that make it easier to purge people from the voter rolls. The vote that ban people from giving you water if you've got to stand in line because, you know, you've got to take a day off work. They cut down the polling booths. So you might have to drive all the way across town, stand in a line all day to get to vote, and nobody can hand you a drink of water. You can't run to the toilet, can't do anything. So these laws are pretty sweeping in their scope. So we marked 2014, a Sunday law, the takeover of the Republican Party. And then, so 2013, Shelby versus Holder, 2014, Sunday law, 2016, the election, the first election after Shelby versus Holder, the first election without the protection of the Voting Rights Act. So immediately the Democrats are going to get to work and they introduced this bill into Parliament. It's called the For the People Act, HR 1. That number 1 is that numeral suggests that it's their priority. It's number 1 on their agenda, their first legislative priority. And this is a sweeping democracy reform bill that wants to expand voting rights because they realise the problem. It's going to also ask for a change in campaign finance laws to reduce the influence of money in politics, limit partisan gerrymandering, and create new ethics rules for federal House office holders. And then there's the John R. Lewis Voting Rights Act, which is HR 4. This was designed to restore the protections of the Voting Rights Act. So these laws have been put to Congress a number of times, and they're pretty much just sitting there dead. Nothing really can be done. The bipartisan support is lost now. So it is a very partisan Congress, and they don't get further than the House. And if they get further than the House, they get knocked back in the Senate. So the bills are there to try and restore the protections, but they're dead in the water, really. Here is a list of ways that women's votes are suppressed. A lot of people were shocked by the Dobbs decision, the overturning of Roe versus Wade. But once you weaken something as fundamental as the Voting Rights Act, anything is on the table. If you can gut the VRA, you can overturn Roe versus Wade. Once they take away voting rights, they will take away all the other rights that are guaranteed by the right to vote. So abortion and democracy are not two separate issues. They are the same issue. Voter ID laws disproportionately have a negative effect on women because of the name change. I'll leave you to read this in your own time. LGBTQ votes are also suppressed. There's a lot of tactics to suppress those, again, because of voter ID and other things. And we might just leave that there for time. Some more reasons, ways that LGBTQ votes are suppressed. Okay, so stop share. So what we've done is we've walked through the history of voting rights in the United States, as I think that it can be seen important, linked to the name of Fabii, connected with Sunday law. So voting rights, elections are connected with Sunday law, as seen by the name Quintus Fabius Maximus Gurgis. And we can see that they have been an issue with the United States right from its inception. So 2024, it's a big year. There are more than 70 elections in 2024. 4.2 billion people are voting, more than half the world's population. But which election is the most important one that we want to consider? Of course, it's the glorious land. So we want to consider the glorious land. So to do that, let's go back to the name, Quintus Fabius Maximus Gurgis. So we have prenomen, nomen, cognomen. So the question, I'm hoping to have shown how vital voting and elections are to the United States and to human rights and democracy, but we also want to know when. So which election, when is this so important? So prenomen for is Quintus. Nomen, Fabius. Cognomen, Maximum Gurgis. Fabius, voting, elections. Maximus Gurgis, maximum flood, which equals Sunday law. Quintus. So you were named Quintus for either one of two reasons. You were the fifth child born, or you were born in the fifth month. In 272 BC, or 275, in the 200s, in that time period, if you were born in the fifth month, when was that? So we need to go back to the Roman calendar, because that's what was being used in 273 BC. The Roman calendar was a lunar calendar devised by, they say traditionally, Romulus, first king of Rome, and that was (753 BC), thereabouts. The Roman calendar only had 10 months, named after Roman gods. So there was, it began in spring, and there was Martius, Aprilis, actually combination of Greek and Roman gods. Martius, Aprilis, Maius, Juno, Quintilis, Sextilis, October, November, whoops, missed one. September, October, November, December. So our first 4 months are named after Roman and Greek gods, and then they're basically numbers 5, 6, 7, 8, 9, 10. December, 10, Deca. So Quintilis was your fifth month. But then the calendar changed and we come down to the Julian calendar. And that's a solar calendar and introduced about 45 BC, changes made by Julius Caesar. And what they're going to do is they're going to add 2 extra months, because in the Roman calendar, there was no, they didn't calculate time over winter. So winter was just had an unassigned span of days, unallocated. The Julian calendar is going to change that, and it's going to allocate time right through winter. And it will start in January. All right, January was the first month. Julius Caesar thought, well, we'll start with the god Janus, because he's the big god of beginnings. He's pictured with having 2 faces on his head, one pointing one way, one pointing the other. So Janus will begin, then February, and then March, April, May, June, and then he's going to change Quintilis, and he's going to name that month after himself and call it July, after Julius Caesar. And then the next emperor, he's going to do the same, Augustus. He's going to think he needs a month after himself, and we get August. So that August doesn't happen in 45, it happens a bit later. And then September, October, November, December. So the 5th month on the Roman calendar, Quintilis, equates to July in the Julian calendar. So Quintilis, named after Julius Caesar, the first Roman dictator. Sextilis changed to August. So just a word on Julius Caesar. If we were to look at his name, his full name is Gaius Julius Caesar. So because he belonged to the Julii tribe, as stated earlier. So his cognomen was Caesar. So we know Caesar today as a title, and it has come down since the time of Julius Caesar as a title. And so that we get the word Kaiser and Tsar, words like that, all are derivatives of the word Caesar. It's synonymous with dictator. But it wasn't always a title. It was his cognomen. And as Maximus Gurges was a nickname describing the dissolute youth of the man, Caesar was actually a description of which family that he came from of the Julius tribe. He came from the particular family whose ancestor killed an elephant in the Punic War. I think it was his great-great-grandfather or something. Might even be more greats than that. No, it wouldn't have been more. Anyway, he had a distant relative, and that's the name that would be followed through that family. So this distinguishes Gaius Julius as belonging to the family of the Julii tribe, that particular family of the Julii tribe. And it means elephants. And in the first denarius that Julius Caesar had minted, as they all minted coins after themselves, he had the name Caesar with a picture of the elephant above the name Caesar on his first denarius. So we're going to mark July with elephants. Okay, so 272 BC, if you were born in the 5th month, if you were born in Quintilis, that would equate to being born in July. So what is happening in July of this year? The Republican Party will hold its national convention from the 15th to the 18th. So we mark July this year is the Republican National Convention, the RNC. The DNC will be in August. And it'll be held from the 15th to the 18th. The RNC is an event in which delegates of the Republican Party select their party's nominee for president and vice president in the 2024 presidential election in November. So, in an election year, presidential primaries are held in each state from January to June. These are mini elections to help select the candidate from a political party who will run in the presidential election. And that sounds quite simple, but it's actually very complicated because each state has its own rules and ways of doing things. But from January to June are all elections. So they're the primaries. Let's just have a look at how that works. A very oversimplified version. So say you've got a state, Arkansas, just as an example. That state is going to hold a primary. So if you're a Republican voter, you will go to the GOP primary to cast a vote. If you're a Democrat, you'd go to the Democrat primary election. And then you might go to the GOP primary and you might say if it was 2016, you could choose between Trump or Cruz or any amount of people that are running for that election. In 2024, you might have voted for Trump. If you went to the Democratic primary, you most likely would have voted for Biden. Not necessarily, but the majority did. All right, so what does that vote mean? That vote means that that state can now send a particular number of delegates. So you're going to send RNC delegates GOP delegates to the RNC, to the convention in July. And if you're a Democrat, you're going to send, you're voting to send a certain amount of delegates to the DNC, which will be in August. Now, each party has a set amount of delegates that can come to their conventions. And these delegates fall into two groups. You are either a pledged delegate, depending on the rules of your state, or an unpledged delegate. So with the GOPs, they have 2,272 pledged delegates that will attend the RNC. So we can note the 272 there. What that means is that when they go to the convention, they have to vote the way that state has voted. They have to vote for that, whoever the leading, whoever had the most votes in that particular state. And then there's like, I don't know, another 500, I don't know how many, there's about 2,500 delegates. So let me give you the numbers. There's 157 unpledged. Uh, 2,429 delegates will rock up to that convention. With the DNC, they have about 4,500 delegates that go to that. So I'm just marking a 272 here. It's not a nail. I'm going to put my hat on but it's an interesting number. It's like elephants. It's there. You can do what you want with it. So the others, they could rock up to the convention and they can listen to all the speeches and go, well, Cruz is actually making a good point here. I'll vote for Cruz instead of Trump. Yeah, they can change their vote once they get to the convention. The pledged ones can't do that. And then, then these all go to the general election. Whoever gets voted in as the nominee. So what we have now is Trump and Biden are called presumptive nominees, because it's presumed that they're going to get the nomination at the convention, but they haven't got it yet. So they are presumptive nominees. Something is presumed when it's deemed highly likely. So Biden and Trump are not officially their party's nominees until they win the delegate vote at the nominating conventions. In front of primetime television, each party will officially nominate its joint presidential and vice presidential ticket. There's long hours of state-by-state delegate roll calls with lots of speeches. So it goes for days. It's quite an event. So at what point they actually nominate Trump as the nominee, don't know. I can't imagine it would be the 15th. It would be kind of funny if it was the 18th. But then I can't imagine that it's going to take 4 days to do it, although it really is quite an affair. You know, there's lots of speeches and lots of hoo-ha. So the other main thing so the election of the vice president here is very important, because especially when you've got an incumbent, well, he's not an incumbent, but he's running for the second time, the next elections, people will be looking at the vice president, because that will set the tone of the party. So the election of the vice president is actually pretty important. And in 2016, Trump didn't announce his running mate until right before the convention. But the other very important thing that we note during the convention is this is when they will lay down their policy platform. Oh, I'm sorry, party platform. The party platform is an official statement that outlines the party's stance on various issues, from economic and social policy to foreign and defence policy. These are the issues on which the candidates run for election. The party platform influences politics, appeals to the voters, and gains their supporters. So this party platform that will be handed down at this time is very important. Now I want to share a quote from Ian Bremmer. So you remember Ian Bremmer is one of the heads of the Eurasia Group. And at the beginning of the year, the Eurasia Group lists their top 10 global risks for each year. And we had those put on our media broadcast in January, the top 10 global risks for 2024. And what was number one, top 10 global risk, was the USA versus itself. So during a TED talk in January, where Ian Bremmer is going over these risks, he says the following regarding risk number one. For 2024, we won't have a new president. If there is a new president, that's next year. So why is it so risky now? It's so risky now because the country is so divided, and because Trump is likely to get the nomination, overwhelmingly likely, still overwhelmingly likely. When he does, his policy pronouncements will drive the GOP, and they are not right now, as of today, as of January 2024 and as of May 2024. In other words, overnight, he will regain the loyalty of the overwhelming majority of Republican leaders in state legislatures, in the House, in the Senate, and of Republican-leaning and right-leaning media outlets, and the ability to raise money and to deploy that money for the election. That means that his policy orientations, as he expresses them, whether it's cutting off Zelensky and the Ukrainians, or showing the Iranians what for, and that's why we wouldn't have gone to war against Israel, and the US, if he had have been president, unlike Biden, so he's kind of quoting him there, or in terms of the border, vis-a-vis the Mexicans, and even any other issues, those are suddenly going to be the drivers of one half of the US political system. So it's a deeply concerning political environment, and on that, the US is not in a position to respond to effectively. So that's Ian, what is Ian Bremmer saying? That overnight, once he has the nomination, that is going to drive one half of the US political system, and that is a crisis. So we mark 2014 as the overthrowing of the purging of the moderates from the Republican Party, the overthrowing of the Republican Party. I would suggest that in July at the RNC this year, 2024, that would be complete. Because what are they going to do? I woke up this morning to find that President Trump has been found guilty of 34 felony counts of falsifying business records. He is now a convicted felon, and they are going to vote for nominate a convicted felon as their presidential candidate in July. So I'd like us to consider something about Daniel in closing. We're going to go back to Daniel, and we're going to talk about the everlasting gospel. And we're not talking about the prophecies of Daniel. We're going to be talking about the stories of Daniel. What is the everlasting gospel? It is a three-step prophetic testing message that divides two classes of people. And we see that illustrated in the books of Daniel, in the stories of Daniel. So if we consider Daniel chapter 1, Daniel chapter 1 illustrates the first angel's message. Daniel has to fear God more than he fears the king. He has to glorify God in his body by not eating and drinking at the king's table. And because he's going to be judged. He's going to be judged twice. He's going to be judged after 10 days, and he's going to be judged after 3 years. So we can see clearly Daniel chapter 1, first angel's message. Daniel 2. Babylon is fallen, is fallen. Second angel's message. That image from the top of the head to the bottom of the toe, literal Babylon, spiritual Babylon, represents Babylon in all its phases, and it falls as illustrated in Daniel chapter 2. Daniel 3. Third angel's message. Unrighteous decree, the fiery furnace. We've always associated Daniel 3 with Sunday law. So Daniel 1, first angel's message. Daniel 2, second angel's message. Daniel 3, third angel's message. Don't bow down to the image. Sunday law crisis. These three stories represent Adventism and how the everlasting gospel is going to separate and divide two classes within Adventism. And the three worthies in Daniel chapter 3 represent this movement, because the rest of the Adventists, the rest of the captives are doing what? They're kissing the dirt. But these three worthies are able to recognize the image for what it is when they see it. Why? Because they've seen it before in Daniel 2 in the vision. And why did they understand the dream of Nebuchadnezzar? Is because they had passed the test of Daniel chapter 1. The test of Daniel chapter 1 is that in essence, they were reformers. They kept their identity as Jews, even when they were in captivity. And their identity had very much to do with how I guess the story is in Daniel 1, is what they're eating. So they kept their identity. They realized who they were. And then because they passed the test, they're able to understand the vision of Nebuchadnezzar and explain the prophecy. They understood the symbols and made right application, so that when they saw the image on Daniel 3, they went, seen that before, seen that on Daniel 2. They knew something important was going to happen in Daniel 3. The orchestra was practicing on the plain of Dura. There were major public works going on. There was agitation. But until that sheet came off that image, they didn't know what was under that sheet, but they knew it when they saw it. And that's Daniel chapter 3. So we've got three more stories. Daniel chapter 4. First angel's message. Daniel has to go to the king and say, you need to fear God and stop giving glory to yourselves. You need to understand the reason that you exist is to look after the poor and the widows, get back to the business that you were raised for, or you're going to get judged. You're going to end up eating grass for 7 years. So the first angel's message is given to King Nebuchadnezzar. Daniel chapter 5 should be obvious to us all. Fall of Babylon. Many, many tekel you fasten. You've been weighed in the balances and found wanting. And then Daniel chapter 6, unrighteous decree. Again, representing Sunday law. So what we want to do to understand Sunday law is bring Daniel 3 and Daniel 6 together. And how do we understand Daniel 6? What was the issue? Who you were going to pray for? Who are you going to pray to, I should say? Who are you going to pray to? It was about prayer. And what prayer? 3 and 6 is 9. To understand Sunday law, you must understand Daniel chapter 9. What is he doing in Daniel chapter 6? He's praying the prayer of Daniel chapter 9. This is the first year of Darius the king. This is the first year of Darius the king. He only ruled for 1 year. He's praying that prayer. He knows where he is in prophecy. He knows Jerusalem needs to be restored. And yet there's an unrighteous decree that will restrict him from putting lost my train of thought. So what are your choices here in Daniel chapter 6? I would suggest you've got 3 choices. You can pray to the king. You can pray to who you want to pray to, like Daniel wants to pray to his God, or you could not pray at all. So you don't have to pray at all. You don't have to petition the king for anything. You don't have to petition your God for anything. Just don't pray. So there's 3 options open to you in Daniel chapter 6. So as the first 3 stories represent Adventism, these last 3 stories represent the United States, the institution of the United States. And as noted before in presentation by Elder Parminder, Daniel here represents the institutions that keep the king in check. And that role is taken away from Daniel in Daniel chapter 6. So how would we see that happen in our time? So I want to share, this will be the last thing I want to share this morning. So the New York Times has a podcast, The Daily, and they had an episode called Trump 2.0, What a Second Trump Presidency Would Bring. And they have 3 political journalists that contributed to that podcast that are writing. They actually write together for the New York Times covering the presidential campaign of Donald Trump. So Jonathan Swan, Maggie Haberman, and Charlie Savage. Jonathan Swan, I want to quote a portion of what he said on this podcast. We should be familiar with Jonathan Swan here. He, or maybe everybody should be. Jonathan Swan was a political correspondent who won an Emmy Award for his 2020 interview with the then President Donald Trump. He was working for Axios. If you haven't watched that, it's worth watching. He won an Emmy for that. He's actually a son of Dr. Jonathan Swan. So an Australian who now works for the New York Times. So let's read what he says here. Trump wants more power for its own sake. And at the same time, there are people around him who hope to achieve certain policy goals. And they've identified that the best way to do that is for Trump to accumulate the power that he wants. So together, they've collectively determined that the way to accomplish all of this is to remove the encumbrances and obstacles that stood in Trump's way the first time and make sure that they are not present in a second term. So as we're reading this, I want you to think about Daniel chapter 6 and the role that Darius takes and the role that the other presidents take. So we see two groups here. Trump wants power, but they're also surrounded with people that want power for their own reasons as well. How might Trump and those around him achieve this logistically? By looking for people that are much more ideologically aligned with him. And he's focused on finding a cabinet full of people who are going to find ways to enact the policies that he wants. These people won't oppose him on any views or whatever his agenda is in that moment, whether that's foreign policy or whatever. People that help him get to a yes and not a no. Trump's biggest regret from his first term is personnel, the people he hired, which includes all the generals, all the people that now say that he was unfit to serve. The people that surrounded him for the first 2 to 3 years of the administration, those that saw their job as protecting the country and the world from Donald Trump. In his last year, he cleared out several of these people that he regarded as disloyal and replaced with others that he knew would follow him. But in his mind, he knew he hadn't gone far enough. There is a layer of power and potential constraint that exists less in the public eye, one layer below the cabinet official, which is the top lawyers in various departments and agencies. The lawyers occupy a unique niche in the government because they are about what is permissible, and if they say no, it's a real problem. These lawyers were politically appointed, Federalist Society, Republican-leaning conservative, but they were a constraint. And now there is a split between the MAGA group and the Federalist Society, where the MAGA movement sees them as too willing to say no, too willing to ask rule of law questions, and they want a different type of lawyer. Trump wants to get rid of what he describes as the snakes, the lower level government workers that he thinks of being the heart of the deep state, that testified against him during his first impeachment. Who are these snakes? And what is the plan of getting them out of Trump's way? One way to think about the federal government is that there is this rotating layer on top of about 4,000 political appointees that get replaced every time a new president comes in. But below that is this mass of 2 million plus career officials who have pretty good protections. There are all of these procedures that you have to go through in order to fire someone. They have lots of rights as an employee of the federal government to object or to appeal, and that is by design. The design is a non-partisan, professionalized workforce that does not change every time there is a new party in power, but actually develops an expertise over a number of years. And these are the people who come up with the rules that regulate mundane stuff like clean drinking water and food regulations. James Shirk was tasked with answering the question of how do we fire more people? How do we get more of our own people in? And how I've just inserted some information on James Shirk. He had previously was nationally recognised as an expert on the civil service and labour policy, and you can read the rest in your own time. So this James Shirk, He came up with this idea called Schedule F, which is an executive order that Trump issued in October of 2020, his first term. It didn't get much attention at the time because of the timing and didn't get enough time to properly implement it. But it would allow them to reassign, they estimated, 50,000 people who they had determined were involved in some way in affecting policy. What this executive order would effectively do is turn these civil servants into political appointees. You are now Schedule F. It would allow them to fire as many as 50,000 and replace them with their own people. Trump's closest advisors don't believe that they will need to fire necessarily that many people and replace them. They believe that the threat of the order will have a chilling effect and will force the people into line and will make them stop trying to slow walk or obstruct. If you know that your head will be chopped off, you might salute a little quicker. I've inserted that. You don't have to throw everyone into the lion's den. So that's the implication I'm making there. Schedule F has not been tested because Biden immediately rescinded it as soon as he came in. But it will be the Trumpified Supreme Court that will ultimately decide whether or not a president can do this. The 6 conservatives on the Supreme Court are part of a conservative legal movement that predates Trump, that has been interested for a generation or more in centralizing greater power over the government in the White House itself. And a huge component of that is increasing the president's power to remove people that do not do exactly what he wants them to do. So I would like to suggest that we can see how Schedule F would fit into the narrative of Daniel chapter 6. So running out of time, I don't want it to be too long. So I am suggesting that Sunday law could begin in July of this year, which is, excuse me, only weeks away. That I remember Elder Parminder saying that we could walk through Sunday law. And I think it is just something, it could just be, look like a blip on the calendar, but that it will have a significant effect. So they're my thoughts on the Sunday law. I won't take the time to review because of time, but I would like to leave you with some things to think about because there are obvious problems. So I'll share what I think are problems. So we note 2021 as Beneventum Paneum 275 BC. 2022 as our increase of knowledge 273 BC. Dobbs versus Jackson's Women's Health Organization, the overruling of Roe versus Wade. And then what I've just done is I've jumped to Sunday law and I've said 272 BC is 2024 and July 2024. So one, I haven't picked a particular day because I wonder if it actually really matters. I'm wondering if we're going to head into a time where we might not necessarily have particular days where we can mark internal and external events that can mark these significant turning points, but nevertheless, it might be a significant day, but between the 15th and the 18th. So what's missing is we've got a formalization. So I have some thoughts on that as well, and I'd be interested in your thoughts. Is there something that we've walked through and that perhaps we've missed? So that's a thought to leave you with. The other thought is Quintus Fabius Maximus Gurgis. The emphasis in this movement up to date has been on Maximus Gurgis, the maximum flood. And I would say that is the right emphasis. Our fear is the flood. It's not the when. If it's July, that I think that's important for us to know, but it's the flood. Whether it's when we looked at the history of the wilderness, the beginning of the wilderness, 538, and its end in 1798, we see 2 floods represented there. We bring them together to give an understanding of the flood that we will experience. It's the flood that will overthrow God's people. So the emphasis has been on the flood, and for a very good reason. So it is time to understand and use our methodology, that we don't be swept away with the abundance of information and teachings that could come our way. There are floods external and there will be floods internal. So I leave you with that thought, and with what looks like about 3 hours to sift. And I wish you all well, and God bless. Let us close in prayer. Our loving God in heaven, we thank you and praise you for Daniel, the prophet, and John, the revelator, for all the people that have gone before us in the past history, recent history, and those in our movement that have given us such great truths that can guide us. Help us to understand these truths and to apply them correctly. I pray for this movement, pray for the ministries we represent. We pray for our families and our loved ones. And we put all things into your hands and ask this in Jesus' name. Amen.